Good afternoon, everyone. I'm Carlton Mays, Vice President of Sales for QDRO Council. Thank you for joining us for the 9th presentation in our QC webinar series. Today's webinar will focus on how to get started on QDROs, and the topics to be covered are: at the beginning of the dissolution process, start thinking about retirement funds. We will also discuss various types of retirement plans, how to proceed with discovery strategies for finding and naming plans, what questions to ask your clients, how to spot potential issues, and how to protect the client's rights and interest in the account. Our expert speakers today are Louise Nixon and Lorena Duffy. Louise is a nationally recognized QDRO expert. Since 1994, she has practiced law, specializing in retirement benefits division and QDROs. Louise is a recurrent family law court-appointed expert on QDROs and speaker on the subject. She has been quoted for her expertise in the Bloomberg Report, New York Times, and the Wall Street Journal. She was awarded the Pro Bono Attorney of the Year by the Harriet Buhey Center for Family Law, a nonprofit which provides free legal services for low-income families in turmoil, and she currently serves on its board. Louise continues to practice law with QDRO Benefits Law Group and is a member of the Quadrones, a national study group comprised of QDRO attorneys and pension valuation experts. Lorena is a nationally recognized QDRO expert, also with a diverse background in QDROs and family law. Lorena is a recurrent family law court-appointed expert, frequent speaker on QDROs. She has practiced law since 2006, including as an attorney for the Legal Aid Foundation of Los Angeles. Lorena is the president of the Latina Lawyers Bar Association, which services include providing Latinas with a community of support, together with specific resources and tools to allow them to achieve their greatest potential, and provides law school scholarships. She is fluent in Spanish, and Lorena practices law also with QDRO Benefits Law Group and is a member of the Quadrones. Please know that your microphones are turned off, and if anyone has any questions during the presentation, please use the Q&A function and post your question, not in the chat room. We will address all questions. Louise and Lorena, it's yours to take it away.
Thank you, Carlton. So throughout the presentation, I'll be going through PowerPoint and also the platform. So just I appreciate your patience as I'm navigating. It's so great to see so many people interested in QDRO Council. As I'm sure you all know, previously, retirement benefits were sort of an afterthought in a divorce. It wasn't until post-judgment that it was really dealt with. QDRO Council changes the paradigm in that, and now you can sort of deal with retirement benefits in the forefront. And so it's a really exciting time in that you have access to all this information, and it's the first time this has ever been done, so that you can understand the retirement benefits and divide them yourself. And I hope to show you sort of the basics today of how you can do so. So I'm going to switch over to our PowerPoint, and again, I'm going to be switching back and forth, so just I appreciate your patience as I navigate that. Okay, so QDROs, how to get started. I'm going to show you the sort of the experts, both attorneys and valuations experts that you can access through QDRO Council. We have Louise Nixon, myself, John Madden, Matt Schwartz. There's our pictures if you want to know what we look like. Okay.
And just to interject, let me just, hi everybody, hi, Louise. I can't help myself. I also know John Madden is available, and if we have certain questions that you want to direct towards him, we can bring him in. He's listening right now to the talk.
Thank you, Louise. So today's focus is just sort of the basics. Where do you start? We're going to discuss the types of retirement plans, discovery strategies, the importance of sort of doing some research to identify the plans and naming them correctly, what questions you need to ask your clients, how to spot potential issues, and how to protect your client's rights in the retirement benefits. Okay, so we'll start with the 5 questions to ask. And again, QDRO Council is changing the paradigm. Usually retirement benefits were, an afterthought to be dealt with by someone else after the case is done. But the right time to be thinking about retirement funds is at the beginning of the case, so that you are able to identify what what the retirement plans are, but also do any necessary discovery and also divide them appropriately for your case. You can use them as a bargaining tool. So switch to the next slide. Okay, statistical information. So this is, basic information that you already probably have in your case. And I'm going to switch now to our platform. Okay, so this is the member dashboard, and this is pretty much where you're always going to start. And there's so much going on here, and I'm going to walk you through it all. But today, again, we're going to focus on the basics. And in our other monthly webinars, we'll go into detail on other areas. So here you have sort of all these buttons that you can click on to draft orders, whether they be for private plans, public plans, IRA orders, military plans. We have our calculation suite, jointers, judgment language, notice of adverse interest. I'm going to go into that later on today. And then you have quick links down here. Once you're more familiar with the QDRO process, you can click on these links and get to exactly where you want to go. And then you have resources here on the far right. But for today, we're going to start as sort of where you would start as you're new to QDROs. We're going to go to the case management tool. Okay. So the first thing is, if you're starting to do QDROs, if you wanted to get some ideas of how to integrate your practice in the QDRO area into your retainer agreement, there's a sample retainer agreement and some language that you can use right here, but I'm not going to go into it, but you can click there and get some more information on that. But we're going to start with the client memo. And I'm going to have to do a new share, so just give me 1 second, I want to show it to you. Okay, so this is what we like to provide our clients and our customers to describe what the QDRO process is. But if you're new to QDROs yourself, you may want to read this as well to understand the different steps and to understand questions that you or your clients may have. So this is something that you can, again, use for yourself or use for your clients or your customers, whatever it may be. It sort of asks and answers the main questions that you may come across. And I'm going back to the platform, and thank you for your patience. Okay, so now we're going to actually start the case management tool. Okay, so step 1, questionnaires. I'm going to click on questionnaires. So I can imagine that most of you are maybe family law attorneys, or a lot of you are, and you probably have a packet that you provide your clients at the start of a case to get information. So we always start with a general questionnaire, which has the basic information that you're going to need, right? You're going to need to know who the plaintiff is, the petitioner, the respondent, the applicable dates of marriage and separation, their address, their social, their date of birth. This will give you everything, all the basic information that you need. So you can easily integrate it into the questionnaires that you provide your client when you're doing the initial client interview, or, it just has the basic information that you need.
I'm just going to interject that Lorraine and I kind of work this out where we're both talking, Lorraine is leading, and I'm going to hopefully be able to provide a little more insight on certain things. Just in terms of, I know how it is. You get a case and you're like, where do I start? I know that this person is employed, or the ex is employed. And I can't tell you, I mean, if you're just getting this basic information at the beginning of the case, especially from both sides, when both sides are cooperating, it's very helpful so that you're ready to go when it's time to do the QDRO or even the judgment language. You have more information. So the general case information is always critical for any future QDRO. When at the beginning of the case, in most plans, I mean, especially if you're a mediator, I know we have some divorce financial professionals out there. This information is worth trying to get while everybody's cooperating.
Thank you. So next, we're going to go into the plan-specific questionnaires. I'm going to click on that. So as maybe some of you know, maybe not all of you know, there's two types of retirement plans. The first one is a defined benefit plan, and that's what you think of as, or what you primarily know as a pension plan. So these type of plans are what I like to characterize as the good retirement plans, where at retirement, you get a monthly amount for the rest of your life, right? We all want those. I wish I had one of those. So that's the first type. And so the questionnaire, the first questionnaire you'll see here is for private employer defined benefit questionnaire. And again, today is just covering the basics. So I'm focusing on private plans. But if you tune in to our future webinars, we're going to cover other types of plans, like public plans, IRAs, military, all that good stuff. But today, just think of everything I'm saying as general, but also specific to private plans. So these questionnaires, again, they can be sort of consolidated with your general information, sort of your client intake questionnaire. I know those are a lot of family law attorneys that use those, or you could sort of do it later. It's up to you. But this has all the questions that you should be asking regarding the retirement plan. And it also helps you identify potential issues that you may need to address. So you want to identify who the participant is. You want to identify the name of the employer, when they started working there. Are they a highly compensated executive? Is there a previous QDRO? You know, this is important to know. Maybe that person was married before, and so the first spouse already has a chunk of the pension, and now the second spouse is going to get another chunk. You know, things that you wouldn't think to ask. It points out the issues here. Usually for defined benefit plans, the most important question is number 8. Are they retired? And that's for the most part, the most important thing to know for a defined benefit plan, because depending on the answer to this question, you're going to figure out what type of QDRO you need. Okay, do you need one for a person that's retired or a person that's still active and accruing a pension benefit? And if they are retired, you're going to want to know what is the form of pension benefit selected at retirement. And the reason why that's important is oftentimes, you know, when someone retires, not oftentimes, all the time when someone retires, they're going to select how they want to be paid out. So a pension benefit, a defined benefit pension benefit is based on the following. And this is general, there's a few deviations. It's based on the pension credit earned during marriage. It's based on their salary. It's based on their age and their sex at retirement. Based on those factors, they come up with a monthly amount that they can pay someone for the rest of their lives using actuary tables. So at retirement, if a participant, and that's the employee, chooses a single life annuity, you see that right here, that means the pension's only gonna pay out during their lifetime. If they choose a joint and survivor annuity, it's paid out for their lifetime plus their spouse's lifetime. So if you're dealing in a divorce with someone who's retired, you would want to know the answer to this question. In their discovery, you may want to ask for their retirement application, because maybe someone is saying one thing, but they're not remembering correctly, or maybe they're not disclosing that information. So those are the two, I think, most important issues that you need to identify for a private plan. Are they retired or active? And if they are retired, what option was selected? And the reason why this, and I don't want to get sort of too much into the sort of details and of why you would want to know, but for example, if you had a participant who retired, let's say post-separation, they probably chose a single life annuity, which means they will only get benefits over their lifetime, meaning there will be nothing left for spouse. And that may be a reason why you want to negotiate differently in the divorce case. Maybe you want to, because there's going to be a loss of survivor benefits, because the benefits are only going to be paid for the participant's lifetime, not the non-participant, the wife or husband, whoever the non-member is. So I just want to throw that out there to sort of start you thinking on possible issues. And then the second page, again, is just more just talking about other questions that you may want to know the answers to about how you may want to divide the plan. I don't know if you have any thoughts on that, Luis, before I get to the defined contribution plans.
Well, yeah, a couple things. And I mean, I would say that you hit the major points. The one, you know, for highly compensated, if you have a feeling that, especially if you represent the out spouse, that there may be non-qualified plans, you want to find those out at the beginning of the case. And if the person is a high earner, then that is an important question to ask and look into, because those are not a lot of times easily findable when QDRO Council can help you find them. The other thing is, you know, in terms of how you divide, and I have to go back to the PowerPoint, that we would normally divide a defined benefit plan with a time rule formula, and what we want to impart in this particular talk is that if you can find the basics, just even the name of the employer, based on the law and how you know how we know how plans operate, QDRO Council can help you figure out the rest, and that takes a lot of burden off of your staff and you trying to figure out, am I missing a plan? That's another huge issue. And if you're, especially if there's going to be a potential loss of survivor benefits, if you should negotiate for life insurance, things like that. The other thing is we have these questionnaires grouped with both, because there are two types of plan: a defined benefit plan, which is the monthly payments over a lifetime, and defined contribution plans, because one of the biggest problems we see, and we see it in, I don't know, 40% of the judgments, 30%, I mean, it's substantial, is an omitted plan. And usually it's the defined benefit plan that's omitted because that doesn't show up on the pay stubs for private plans in particular. And so people don't know about it. They somehow think that they have a 401k and everything, including the defined benefit plan, is in the 401k. So we've purposely grouped the questionnaires naming both types of plans, so you're forced to look into it and make sure you're not missing a plan. Cash balance plans, also we have questions on them in the defined benefit plan questionnaire, because they're actually defined benefit plans and they are treated differently than than the traditional monthly payments over a lifetime defined benefit plan. So these are just triggers with a questionnaire to figure out where you are in the case. And it's fantastic. I know that some of you out there are subscribers and we've gotten really wonderful feedback and we really appreciate it. But I know that that having this resource has been really valuable. It's been valuable for my staff too, to figure out when the case comes to the law firm, how to handle the plan. So, okay.
Louise, this prompted a question. Can you change a single annuity to a joint and several annuity after the employee spouse is retired?
Do you want to take that, Louise? I'm happy to take it.
No, you
So
take it.
The important reason why if someone is retired, you want to ask what option they selected is because it is irrevocable, meaning it cannot be changed. So once an election is made and a check has been received, that's it. It's a done deal. And sometimes I'm going to give you an anecdote just because to explain let's say the parties decide jointly, we're going to choose a single life annuity so that it only lasts the employee's lifetime. Usually the employee's wife has to sign off on that. Usually, not always. which means and it usually has to be notarized. And it doesn't matter if employee dies 2 months later, the pension stops. So yes, you have the option of receiving a greater monthly amount, but once the employee dies, it is over. So that's something important to know when you're negotiating and you're doing discovery and you're strategizing around how to divide the community property estate. Is that very fact? If a single life annuity and let's say the the wife is a lot younger than the husband, things like that are gonna matter. So. And again, feel free to ask more questions throughout. I'm going to move on to defined contribution plans. And I'm also going to go talk about plan, just so you know, Louise, I didn't forget, we're going to do some plan research too. So the second type of retirement plan is a defined contribution plan. And those are what not what you normally, it's essentially a 401k, but it can be called a savings plan. It could be called deferred compensation. There's tons of different names, but essentially, it's you're contributing to that plan and your employer is matching and you're deciding, or your employer has a default investment choice, you're deciding how to invest it. And you're going to get statements either monthly or quarterly or yearly that shows you how your account is performing, not only based on your contributions, your employer match, but also how it's invested. So at any given point in time, the value of that plan versus, as Louise noted before, for a pension plan, you might not know you're contributing to it. And you most definitely usually are not going to receive statements telling you the value because there is no value until retirement. So for defined contribution plans, it's kind of funny because usually most issues arise with these plans. And whenever it comes time to do discovery, other than the discovery noted above for defined benefit pension plans, these are the ones that usually you want to do discovery on. Okay, and the questionnaire is similar to the defined benefit pension plan questionnaire, but this one has the questions are similar, but they have more serious consequences. And so I'm going to start with question number 5, the date the participant entered the plan. For a pension plan, that's not that important for me to know that. It's important to know because I want to know everything, but it's not going to change how I analyze the plan and how I analyze how I'm going to divide the plan. If the participant entered the plan before date of marriage and it's a defined contribution plan, that means there is a separate property interest. So the participant would be entitled to whatever the value of that plan was at date of marriage, plus any growth on that separate property interest all the way through date of division, which is usually the date of separation. So I'm going to want to do discovery around that. And again, whether they stopped accruing benefits is important, meaning they no longer contributed money to that plan. So maybe it's all community. Maybe you can just equally divide it because they stopped contributing during the marriage. Another one is number 8. This is an important one. Did the participant roll over separate property monies from an IRA or another employer-sponsored 401k plan during the marriage? People do that quite often because you change jobs and you want to take your 401k with you. And it sounds like a good idea, but it usually messes things up on our end, but people do it all the time. The other important question is number 9, is there a loan balance? So the presumption, as I'm sure you guys know, is that any, whether it's an asset or a debt that happens during the community property period is equally divided at a divorce. So the presumption there is that if a loan was taken during the marriage, that it is a community debt. Of course, that presumption can be rebutted, but it usually is considered a community property debt. Also, when an employee leaves employment, they may have taken a distribution. And I have it here as a withdrawal, but they may have taken a distribution. And if that happened, you would want to know, especially if it happened after separation. Because again, if it happened during the marriage, the presumption there is that it is a community debt or a community distribution or a community withdrawal. It can be rebutted. Sometimes parties leave jobs or stop contributing around the time of the divorce. And if you know that the employee took a massive distribution to hire, a really expensive lawyer, that's obviously, something that you want to point out that the community did not benefit from that expenditure. It should be a separate property distribution or withdrawal. Okay, so the questionnaire also addresses the different types of division methods for a defined contribution plan. And I mean, we're going to go into drafting QDROs for defined contribution plans again in a future webinar, but I just want to walk you through the four most common options. Option one is a percentage of the participant's total account balance as a specific date. Again, that is usually the date of separation here in California. The second option is a percentage of the total account as of date of account segregation. And that is a future date. That is whatever date that the account is divided, it's going to be equally divided based on that percentage. So if it's 50%, then the account's going to be equally divided. The third option is a specific dollar amount as of a specific date. So maybe the parties agree the non-member or non-alternate payee is going to get X amount as of X date. And the fourth option is where there is a flat dollar amount as of whenever a separate account is created. For defined contribution plans, the biggest issue is again the separate property issue I discussed above, loans, and also investment, whether the award includes investment earnings and losses. In California, the division of the community property estate and retirement benefits and retirement plan includes investment earnings and losses, but the parties may want to agree not to do so. You know, as the account increases in value, both parties share that increase, but if it decreases, you share that loss. So it's risky either way, depending on what's going on in the market, but you want to make very clear whether the award is including investment earnings and losses or not. Okay, so now I'm gonna again.
Let me just comment 1 second on which you'll go into, and we'll do a whole talk with John Madden on it on the separate property interest, because I would say that is one of the big. I would say most people are moving jobs and marrying and remarrying, and so there's this separate property premarital interest is a huge issue. It's about half the cases that come to QDRO Council, and if you can, we have QDRO Councils developed with the help of John Madden and Matt Schwartz, a calculation suite. If you don't have records available, we have different estimates and ways that you can estimate to come up with what would be a fair separate property versus community property value. We're going to be doing a whole talk just on that. But I wanted to point that out, that there are ways to resolve that problem if there are no statements available for a tracing, which would need to be done. And I just wanted to also say that one of the biggest issues that we see in the QDRO world, that we get the call post-judgment, people call and say, okay, I'm done, and I'm told I need a QDRO. Can you do it in a week? And then we find out there's a separate property issue, and in some cases it causes the whole case to not unravel, but it causes a time and effort and money for both parties to dig back in on a case they thought was already done and completed. So regardless of what kind of divorce professional you are that is listening today, I would say that this defined contribution plan issue is a huge issue, and it's a wonderful opportunity for you guys to take the time, and also you should be paid for taking the time to figure this out before you actually do the divorce, write the judgment language. So I just had a case, and we get involved in sometimes, brought in, QDRO Council gets brought in the case, in the middle of the case before divorce, and we can figure out, instead of the divorce judgment saying 50% of the community property in California, that's what it would say, we can come up, if there's a separate property interest, we can come up with the value that the X should get because there's a separate property. We got to come up with a number and say, 100,000 as of a certain date goes to the ex-wife. So this is much easier than to subsequently do a QDRO. And those options that Lorena went through, option 3 is the one you would choose, because that's one of the ones that is used often when there's some sort of separate property premarital interest. So they're just, this is all here to help as a tool, and these issues, pre-judgment, spotting them is is a wonderful opportunity for you guys.
That brings up a good point, Louise. And so as a former family law litigator, I would have loved to have access to this. Because as you know, oftentimes people don't address QDROs until post-judgment. Discovery period is closed. And now someone's making a claim for a separate property interest that wasn't even addressed in the judgment, whether it's your client or the opposing party. And you're thinking, why didn't you disclose this? Why didn't you claim this? You can do a request for production and ask for all documents, relating to the defined contribution plan. If they don't produce the documents, or if they don't produce any documents, you could do a request for admissions and make them, admit that they don't have a separate property interest. And then you just say, you know what, it's done. Discovery's over. You said you didn't have a separate property interest. We're equally dividing it as of date of separation, and issue resolved. And I mean, it's just an amazing tool you can use. And again, this has to be done during discovery. So you have to deal with the retirement benefits from the beginning so that none of these issues later arise towards the end of the case. Discovery is closed, and now all of a sudden and judgment's entered, all of a sudden someone's making claim for this massive separate property interest. That should have been resolved earlier because they should have disclosed it. And they didn't, and now they're just blowing up the case like Louise just mentioned. But if you had done the request for production and then did a request for admissions or whatever it may be, or interrogatories, whatever you want to use, you would have resolved it, and you would have said, hey, this, you didn't respond to it. You admitted you didn't have a separate property interest. We're done. It's just another way you can use discovery and knowing what the issues are at the beginning to strategize and resolve issues in your case. Okay, so now I'm going to go back to the dashboard. So we covered general case information and private plan. Now we're going to, 1 second. I want to go to step 2, find your plan research. So as Louise was mentioning earlier, a lot of times plans are missed. A majority of times plans are incorrectly named. Again, for defined contribution plans, people think those are the only plans that exist and don't realize that there's a whole pension plan, and it's, it's significant marital asset, but it's missed because no statements were received. Or it's misnamed and missed, and 10 years later, the parties are coming back trying to resolve things, and there's been corporate mergers and all sorts of things go on. So you want to sort of, when you're meeting with your client and doing your initial client interview, get an employment history. You want to know all the places they worked at and to sort of find out how long they worked there, because they may not know what the name of the plans are. And that may be work that you have to do. You just have to know where they worked and create an employment history for both your client and the opposing party. And so and you guys can see the screen, right? Private plan research. Yes.
Yes.
Okay. Just making sure. Okay. So in this, you have access to thousands of retirement plans. This makes your job easy. If you have a client and their former spouse says, okay, I don't know what plans he has, but I do know he worked for SoCal Edison. So then you're just going to put in here. Oh, I already did. I'm going to click on that. And it's going to pull up for me all the plans associated with Southern California Edison. So I'm going to know right here that they have a defined benefit plan. That's what DBP stands for. And the name of that plan is the Southern California Edison Company Retirement Plan. So I know they have a pension plan. And then I'm going to look down here, and they have a DCP, which stands for Defined Contribution Plan. And their plan is called Edison 401k Savings Plan. So now I know I can identify the two plan names, and I can do discovery around those two plan names, or I can just proceed to prepare QDROs for those plans if we all know that those plans exist for those parties. And I know what the plan address is if I want to serve, just, if I want to do a subpoena, or I want to send them with jointers or a notice of adverse interest. I have the plan contact information. I have their third-party administrator information. The third-party administrator is where I would send a proposed QDRO. And that's all here for you. And again, you can use this to, you could do it for as many times as you need to and put in all sorts of employers. You could just say, hey, he worked at or she worked at Burger King. What plans are there? And, you know, it pops up and I have all the information here. So there's just, you know, a wealth of information there with identifying the types of plans that are available and where to sort of their address and their TPA information. Go back.
And anything that with QDRO Council as a resource, any if you need to verify or for especially if you're sending an individual case to us on the individual side, well, we will figure out if for whatever reason, if the plan was frozen, sometimes they don't show up, or if it's a new plan that we haven't added yet because we're always updating, won't show up. But we will do the research and figure out the correct plan name. Sometimes people are searching under a certain employer and there was actually a merger, and so the plan name will only show up under the new company with the merger, even though you're looking under the name of the former employer. So those are the issues that come up with the plan research, but our database has over 200,000 plans in it. It's all the qualified plans that are in the United States. So it's a very robust database to help solve this problem of missing plans.
Thank you, Elise. And based on what you just said, think of QDRO Council as your back office. You have at your fingertips QDRO experts, QDRO attorneys, valuation experts, that if you have any issues, if you can't find a plan, if you don't understand what's going on, you would just go here. I'm on my member dashboard and I'm looking at service and support, and you would click here and you would just choose a category and provide your question, fill out your information, and you get a response. So you always have access. You're not on your own. You're not lost. You know, if you're ever lost or if you ever have questions, you just reach out to us and you have access to us. You have access to myself, to Louise, to Matt, to John, to other QDRO experts who can help you and lead you and sort of answer your questions and do research if necessary. Go back to my member dashboard. Okay, so then I'm gonna go, sorry, you guys, I messed up and I scrolled back, so I'm restarting my tool just to keep going. Okay, there we go. So oftentimes as soon as you file a divorce and you're starting to do discovery, and let's say you have a participant, an employee who's approaching retirement age, or you have concerns that the other side may be absconding with the money, or whatever your concerns may be, you want to protect your client. You want to make sure that everyone is aware that there is a pending divorce, and that even though the petition includes the automatic temporary restraining order, you still want to make sure that the retirement plans are on notice that they should be expecting a QDRO sometime. So this is where you would, step 3, prepare a notice of adverse interest or California joinder pleadings. And this, I can walk you through. I don't know if we have enough time. What do you guys? Should I walk them through a joinder pleading, or should we just talk about it? I don't know if we have enough time. Although it generates really quickly. But the reasons why you would want to do a joinder or a notice of adverse interest is to make sure the plan knows that there is an adverse interest. Usually these types of things will trigger a hold, which would for a defined contribution plan mean that the employee is not able to change investment options or take out a loan or take a distribution or take a withdrawal. And for a defined benefit plan, they will prevent the employee, the member, from retiring. Because again, once you retire and you choose an option, a retirement election, it is irrevocable. So these are always a good idea to do if you have concerns about the other side taking adverse actions that may impact your client's rights.
And I just want to add, in the age, I mean, this just happened in a case that I was dealing with, where the parties divorced a while ago, and the participant went ahead and retired. There was a judgment with really unclear language in it that says the excess award of the community interest. The participant retired after divorce, so and he retired single, so there was no survivor benefit. we're able to still do the QDRO, but it would be just based on the participant's life. So when participants dies, it would stop. And if they had taken the time before judgment or at least right after judgment to get this done, then the ex could have gotten a pension for her life instead. So it does impact, especially if a participant is older and close to retirement age. It does make sense in a lot of cases in California to do joinders if you can, or the notice of adverse interest. And I think the joinders, I know there may be other programs out there, but ours, all the boxes are pre-checked to where they should be checked for retirement plans. And also, it's done in like 2 minutes. If we have time at the end, we'll take you through it. But I wanted to make sure what else we're going to cover today, Ms. Duffy.
Okay.
Yeah.
I'm going to go back to make sure I covered everything on the PowerPoint. Give me 1 second.
Yeah, that's a good idea. Actually, we could go through that PowerPoint and check the boxes. We covered.
Okay, so statistical information. So we did cover that. I was supposed to go back to the PowerPoint more often. I'm sorry, guys. Okay, correct plan name. Again, the database has over 200,000 plans. If any of you practice in Orange County, you know that you need to have the correct plan name. Otherwise, you have trouble with filing the QDRO. So it's just really important to get the correct plan name, just generally, but also in certain counties, they're sticklers on plan names. And you have access to that through the platform. You want to know their employment history, when they worked, so you can figure out any separate property issues. We covered that. You want to know if they're active or retired. And you know, a common misconception, just so that you can pinpoint this as an issue, is oftentimes when we talk about retirement, they think I've stopped working, so I'm retired, but you haven't started to receive pension benefits. So you always want to make that distinction with folks that you can retire under a retirement plan, but continue working at a different job. You know, you don't have to retire from all work in order to receive a pension benefit, or you could be retired and not working, but you've decided, I want to wait until I'm a little bit older before I start receiving retirement benefits. As you, or you may not know, that the longer you wait to receive retirement benefits, the older you are, the more the monthly amount is that you're going to get. But that's not because, that's a function of how old you are, meaning if you started at 55 versus 65, yes, you're going to get more money a month because you're older and you're expected to live less time. But at some point, you have to sort of make a cost-benefit analysis to say, hey, if I wait until 70, I'll get $1,000 more. But if I die at 71, maybe that wasn't a smart choice. You have to make sort of that distinction with folks. Okay, let's see, next one. Okay, divorce documents. So hopefully, you guys now understand why it's important to deal with retirement benefits at the forefront versus once the judgment's already drafted and now you're just doing the QDROs, because you want to make sure that the judgment has the right division language. Oftentimes, in addition to not naming the plan correctly in the divorce, it contemplates a division that's not possible. It's not possible, or it's not equitable, or it prejudices one of the parties. So for example, and again, I'm only talking about private plans, but I want to give you this as a good example. Some public plans will give yearly statements to their employees telling them, this is what your pension, this is a value attached to your pension plan. And oftentimes some attorneys use that as the actual value of the pension plan. But that's not the actual value. And if you would compare that value to a 401k and do your own offset, I think that's malpractice because it's comparing apples to oranges and it's an incorrect offset. So you want to make sure that you understand the types of retirement plans and how they're valued so that you don't compare one against the other. Because I've seen that in a lot of judgments, and it's scary and it's not fair because they used a fake value of a pension plan to offset against the marital home. Because usually in a divorce, those are for regular working folks, those are the highest value assets, right? The marital home and the pension. So you definitely want to understand that. Oftentimes in a 401k, they have the division based on the marital fraction, which is not appropriate. It's one way to divide it, but it's not the only way. And if there's no premarital interest, you wouldn't want to divide it based on the marital fraction, which is commonly known as the time rule formula. Okay, I'm gonna go to, I don't know if you have any thoughts on.
Yeah, just one quick comment is regardless of if you're coming, because some of you, how QDRO Council can help, regardless of what your divorce documents say, we can still help you, and we always do, and we always will, because they're clues as to what the parties' intention are, and we can usually, in most cases, figure it out based on how the divorce is written and on just basically the parties' agreement post-divorce, because of limitations from the plan on how things can be divided. So that's why this PowerPoint says they're clues that, but I mean, the ultimate would be to have it very clear in the divorce judgment, which we can help you with that as well. But there is default divisions and ways to go. But out of, we list the top 5 things you can get at the beginning of the case, especially if the case is you're coming into it post divorce and you want to do a QDRO. Number 5, you absolutely need any divorce documents or draft judgment language to figure out what the party's intention is for the plan division.
We have a couple of questions. Let me pose the first one for you. Can you discuss the procedure for joining a plan where the employee has retired and the parties agree that payments can continue during litigation?
Sure. So, and this is an issue that often comes up when a member is in pay status with public plans, because sometimes joining the plan will trigger, or even a proposed QDRO submitted to the plan will trigger a hold, and the plan will either hold 100% of the benefits or 50% of the benefits pending a finalized order. Now, not all plans are uniform in how they address whether they're going to it's going to trigger a hold, or B, what they need to remove the hold. But oftentimes what they're looking for is just something from the non-member spouse, the alternate payee, saying, I'm okay with the employee continuing to receive 100% of the pension benefit pending the finalized domestic relations order. Usually some sort of letter or confirmation from the alternate payee is sufficient for the plan.
Okay. Another question. Have you done post-judgment motions for missed assets, the breach of duty to disclose?
So QDRO Counsel is a legal technology company. We're not a law firm, but that's why it's so important to deal with the retirement benefits at the forefront. Because if it's post-judgment and there's an omitted asset, at that point, if the participant, the employee, is not cooperating, then you have to return to court to get that QDRO entered. So you would have to file a request for hearing to get that, a request for order, excuse me, to get that in front of a judge to make the claim for that omitted asset. Now, you could always, family alternate, you can ask for sanctions. You can ask for 100% of the retirement plan if you felt it was maliciously, if you make, I forgot, I don't litigate as a family alternate anymore, but there was that sort of presumption that if you could prove that it was done intentionally, that you could get 100% of that benefit. But at QDRO Counsel, we don't litigate. That's something that the family law attorney would need to do, because it would be a breach of the fiduciary duty from one spouse to the other, especially if it's done intentionally. But oftentimes, actually, it's not. Often it's the misconception that they didn't know that they had the plan, or they thought because they weren't vested that it wasn't supposed to be divided. And of course, vesting has nothing to do whether or not a plan should be divided. It still should be divided. because if the employee vests, then the alternate payee will also vest when and if the employee vests. I don't know if you have any thought on that, Louise, on either of those questions. Okay.
Good, thank you.
Okay. Keep the questions coming. We still have, well, we have 10 minutes. So let me know if you have any more. Okay, so that's divorce documents. Let's see. Sorry, questionnaires. We already covered that. Oh, so we covered most of the things that we needed to cover. Okay. Private plans, public plans, IRAs. So we're going to talk about IRAs, but I have a few minutes. Oh, no, I just got another. Okay, so we have a question on membership options and pricing. So I'm going to leave a few minutes for Carlton and Araceli to address that. So we're going to get there. Thank you. That's a good question, and I'm glad to hear it being asked. So we talked about private plans mostly today. We're going to talk about public plans in future webinars, so I hope you guys will tune in. And IRAs, I like to think of them as the third type of retirement plan because they're not defined benefit plans, they're not defined contribution plans, but they are a retirement vehicle. And for IRAs, it's a lot of discovery, not a lot, but there's certain, similar to defined contribution plans, you should be thinking about whether there's a separate property interest, whether there's been distributions, and how should they be divided? Because IRAs are different because they can only be divided as of the day that they're divided with either an amount or a percentage. There will be no calculation of investment earnings and losses. And they can be divided just simply with the judgment language. So, you know, it's one little thing that you want to make sure you get the judgment right. If you're going to be dividing them, you have to identify with enough specificity the type of IRA and how it's to be divided. Okay, we have a new question. Let's see. What if, as an attorney for one of the parties, wants to use your services and the other attorney refuses and prefers the local favorite of the courts?
We get this question quite often, as you know, so I'm glad somebody asked that. Thank you, Arthur.
So a couple things. So if, you know, the parties can hire a neutral or if they both use a platform, it could be generated as a neutral. You know, at the end of the day, it's always better if one side drafts it, the other side can be sort of take a part of that process and they can generate it as a neutral. Our website drafts it as equitably as possible. We default to the neutral manner in which to divide retirement benefits. Does that make sense? Louise, you want to step in?
Yeah, I mean, I know that what's happened in some cases where one party is a subscriber and the other party isn't, and one party drafts the QDRO, that's the subscriber, the other side wants to look at it. So what they've done is ended up retaining my law firm, QDRO Benefits Law Group, to review the QDRO and provide comment on it as a neutral, as a court-appointed expert, which we do a lot. So that is one way that, and it also is wonderful because it gives the other side, the other attorney, opposing counsel, the opportunity to find out about the website and how it can help them in their future cases. So, so we have found that has worked in a lot of cases. Of course, if I'm not or Lorena's not the hometown favorite, I don't know where you're from, and we have a wide reach, but not every court knows about us, the law firm. Then, you know, of course, you know, I don't know what to say on that except give us a try and see if the judge is happy with it, because we provide a lot of really good information just so you know, with every QDRO that gets sent, whether you're a subscriber or sending individuals to us, we have an explanation memo that highlights the most important points in the QDRO. So a lot of times I know that, you know, for the parties, it's overwhelming. I get it. You're like, they're looking at these documents, like your eyes go dizzy. Like, how do I don't understand this. So we do have a memo that highlights for that specific plan what happens in most cases and why it's drafted the way it is. But it's also a way, if you're having problems getting the QDRO files, that you can show the judge, because the judges don't know a lot about pension division at all. And this is a way for them to not have to read through the entire QDRO and try and figure it out, for them to see the highlights of it. So if you have to do an RFO to get a QDRO file because one side's not being cooperative, our explanation memo, I know, has been very helpful. So.
Okay, we have another question about, are you going to talk about military plans later? Yes, so please tune in. And then I just want to, I know there's 2 other questions, but I just wanted to show you this because I forgot to show it to you guys, and I love this section. So on the member dashboard, you have QDRO explanations, and I think Louise just touched on it right now. And it sort of walks you through all the questions that you may have and all the possible issues. And you just click on it and it's talking about it. And, you know, if there was any questions, you could give this to your opposing counsel or to, you know, or just for your own edification, your own reading. I think it's just such a wonderful, I know, as was said earlier, I was a family law litigator and then I started doing QDROs. I mean, my life would have been so much easier if this existed back then, because it's literally you're being spoon-fed the information. It's just so amazing, and we're just so proud of this platform. But I'm going to go back to the questions. So do you also send a notice of adverse interest to an IRA custodian? And the answer is, again, not all plans, you know, will recognize a joinder, but for the most part, I know we do notice of adverse interest for IRA custodians, and they will place a hold.
Yeah, there's no guarantee with any of the notice of adverse interest, and especially in this with the CARES Act and people being able to withdraw money while still working, which is not normally the case for a defined contribution plan. Having a notice of adverse interest in place which is a document that when hopefully we'll show you the platform in more detail later. We can go through that with you, but it's super easy to use. And I know, and you send it to the plan and it gives them notice. And most of the plans, I would say 90%, 95% will place a hold because they're nervous. I was a former plan attorney. And the biggest thing the plan wants to do is protect the plan from being embroiled in any litigation for paying out money that they shouldn't have paid out. So they're going to be very cautious about it. So they may not permanently place a hold on it until they get a QDRO, but at least it will be enough to, the goal is with notice of adverse interest is to create, you know, at least a temporary hold until the QDRO gets done. An IRAs is very hit and miss. You know, some IRA custodians are going to just throw it away and not deal with it. And of course, you may not know this, but if it's a military or federal employee, notice of adverse interest and joinders have no impact. There is nothing you can do other than serve the actual division order, domestic relations order on those plans to create the benefit to be payable to the ex-spouse, to protect the ex-spouse's interest.
Thanks, Louise. So I want to give Carlton and Araceli some time. Closing thoughts is information is power. Now you have all the information that you need at your fingertips to deal with retirement benefits at the forefront. And we look forward to working with you all. We look forward to seeing you at our future webinars. And thank you so much for spending time with us. And I'm going to hand it over.
Okay, thank you both. As Lorena just mentioned, if you saw the original email, we have 5 more of the monthly webinars, and they're the last Friday of each month, starting at 1 p.m. There were multiple questions about subscriptions and pricing. So Araceli's going to put up, there it is now, you should be able to see the pricing sheet. And also she will post a link to the website and telephone numbers. If anybody has any questions or any interest, we will gladly schedule Zoom presentations and demonstrations of the program and platform. Typically 15 minutes at a minimum. A lot of times it gets into deep dives, similar to what Lorena was showing about all the answers, tips, highlights, cautions that appear in the website, cause them to tend to go longer, but it's really at your discretion. Since there are no more questions that have come up, want to thank you all very much for joining us. Thank you, Lorena and Louise, for hosting and presenting today. and we wish you all good health and goodbye.